Hi again, everybody. This is Edgar Jatu, Executive Director at Workplace Fairness, and I'm joined today by Annika Schwartz, who is the Director of Civil Rights and Employment Case Development at the law firm Cohen Milstein Sellers and Toll PLLC. And today we'll be talking about gender identity discrimination. It's also been in the news a lot, particularly with the changes in the Trump administration regarding gender identity and how it's treated and protected. And we're going to come at it from the employment context, and Annika is going to walk us through the changes at the EEOC level in terms of enforcement of gender identity discrimination cases. And Aniko, to start, can you give us a quick overview of what the EEOC does and its role, particularly at the commissioner level, which is really pertinent to our conversation today?
Sure. Yeah. Well, thank you for having me on, Edgar. So the EEOC, as I think your audience knows, right, was established by Title VII
Yep.
of the Civil Rights Act of 1964 and is charged with eliminating unlawful employment discrimination. And the way it does that is through the dozens of field offices it has around the country that receive and process charges of employment discrimination filed by individuals or by groups of individuals on behalf of groups of individuals, and by enforcement actions that come from the commission itself. So this January, we saw the president terminate Commissioners Burrows and Samuels, which left the commission without a quorum that had been expected to stay in place until 2026. These folks are Senate confirmed presidential appointments that have historically crossed over between administrations. So now remaining are only acting chair Lucas and Commissioner Kolpina-Kodegal. So there's short one member required for a quorum. So during this time, the EEOC can continue to intake, process, investigate, and issue resolutions of charges of discrimination filed with it. The lack of quorum doesn't necessarily impact parties who are currently engaged in the EEOC process. And the EEOC may continue, even through its general counsel, to file some enforcement lawsuits, though there are significant restrictions that apply in some cases.
Yeah. And in terms of what's happening at the commission level, Commissioner Lucas has been handing down certain directives regarding gender identity discrimination. So can you talk a little bit more about that?
Sure. Yeah, so what we've seen is coverage of acting chairperson Lucas's press releases, which cite to, I think you're referring to Trump's executive order, the so-called Defending Women executive order. And these press releases can be read to reflect the acting chair's priorities, which fall in line with those of the Trump administration vis-a-vis the LGBTQ plus community. Acting chair will be likely to prioritize some types of charges over others, and we can talk about those in a bit. But in addition, we expect to see deprioritizing, for example, the enforcement of workplace protections of LGBTQ folks. Conversely, we may see the EEOC eager to single out law firms with DEI programs that have been aimed at advancing the position of historically marginalized communities and suggesting that DEI itself is discriminatory, as was suggested in a technical assistance document that was issued just today between the EEOC and Department of Justice. What this does not mean is also important. These press releases do not equal policy. Prior to the termination of the two commissioners in January, the commission had voted to adopt several meaningful and really important measures, including last year, just in 2024, enforcement guidance on harassment and a strategic enforcement plan that is presently scheduled to remain in effect through 2028. These measures, which were passed by a quorum, they carry the imprimatur of the agency and continue to govern employees throughout the commission. So whatever acting commissioner Lucas has said about the president's executive orders, it is important to note that her pronouncements do not equal formal policy. For example, the guidance on harassment is what EEOC field office personnel look to and should continue to be guided by in their evaluation of charges of discrimination filed by members of the LGBTQ community and others covered by laws enforced by the Commission. So until the President nominates and the Senate confirms replacements on the Commission, it will be short one member required and so limited in its ability to create new policy.
Well, thank you for dispelling that, Annika, and that's a very important aspect of all this that I'm sure people are very confused by. And let's take it down a little further. So in terms of the practical and day-to-day considerations that workers and their advocates have to think about. So we now understand that at the commission level, they can pass down these directives or edicts, but there is no quorum. So what does that mean for the average worker, particularly someone that is complaining either as an active case or a potential case about gender identity discrimination? What does that mean for them in terms of how they can enforce their rights?
Title VII, which includes sex, which has been defined to include gender identity and sexual orientation, folks have the right to file charges of discrimination with the EEOC, which is and has been and will continue to be a prerequisite to bringing claims that arise under Title VII of the Civil Rights Act of 1964 in court. Okay. Ultimately, the EEOC may still issue them a right to sue letter, which is a prerequisite for filing in court. Depending on the nature of the charge, the EEOC might put less effort into investigating than it would have in the past. But frankly, it's only a really small percentage of cases that the EEOC would take on to litigate itself at any point in the past. Ultimately, as long as a worker gets a right to sue and an attorney, or they could go pro se, but we encourage folks to consult attorneys to file in court, any lack of investigation by the EEOC won't materially change their underlying rights or the court's ability to protect them. So even if enforcement approaches and priorities shift, the court's interpretation of Title VII and state-level laws that protect against discrimination in the workplace remain there. It's more important than ever, though, to seek counsel.
Right. And just one other item of clarification. Let's say EEOC had been representing you as a person in a case, let's say on gender identity discrimination. What do those people do in that situation?
Right. Yeah. No, I'm familiar with the cases. Right. These were high profile cases on behalf of specifically individuals who had allegedly experienced gender identity discrimination in the workplace, and with the administration change were dropped. It's my understanding that members of the plaintiffs' bar, of which you have been a member and of which I am a member, have rallied right to support, and that is the case. It always has been and will continue to be, that the plaintiffs' bar will remain vigilant in identifying and bringing claims of discrimination that violate Title VII, the ADA, Age Discrimination in Employment Act, other statutory protections that exist to protect against discrimination. That's the case regardless of who is in the White House or who's heading the commission. It's important for workers to know that the laws that govern workplace conduct are unchanged by Acting Chair Lucas's press releases or other statements of that sort.
Got it. Thank you for that, Aniko. And right now, and in general, what can workers do to protect themselves if they believe they're facing any type of workplace discrimination?
Yeah, I think this advice remains unchanged in large part. Always, workers who experience or are subject to conduct that they think may be illegal in the workforce and are contemplating legal action can protect themselves by taking notes, documenting incidents, familiarizing themselves with the process of filing a formal charge of discrimination either with the EEOC or the state fair employment agencies. They should always take note of relevant deadlines. Those can come up quickly.
Hmm.
Often the clock starts ticking from the date of an incident. Workplace Fairness is a terrific resource to help folks get started. I've referred people many times to the site to get also a sense of what can rise to the level of violating the law versus what is unfair but might not be
Right.
something that's subject to legal claims. And just, yeah, get educated on your rights and stay on top of the changes that are being introduced by the administration. Once again, the Workplace Fairness site is a great resource for all of that. And the EEOC and the courts have previously affirmed legal protections, and to bear that in mind, that no one should assume that their rights have disappeared because of who is in the White House and who's heading the commission.
Yeah. Great. No, that's great advice, Aniko. Thank you so much. And finally, are there any other updates from the EEOC that you want to talk about or bring to people's attention on who will be watching this recording?
Sure. So I think, as I mentioned earlier, the emphasis on targeting DEI programs, on enforcing charges brought by individuals who have claims of religious discrimination and sex discrimination and race discrimination. They do appear to have a different angle than administrations in the past. I don't think the underlying advice to employees changes,
Hmm.
which is if something is unfair and it feels illegal, the law is potentially there to have your back regardless
Right.
of who you are. If you're being treated differently because of your membership in one of these protected classes, it's always been the case that is a violation since these laws have been enacted. So I think it's a lot of headline grabbing statements that we're seeing,
Hmm.
less really reflective of less that is reflective of changes in the underlying law.
Yeah, no, I think that's very well put. And I would just encourage people, there's a lot of dust being kicked up right now in the air. So just take a moment to let the dust settle and really take stock as to where we are, because as Aniko mentioned, there are a lot of attention-grabbing headlines, but there are a lot of things that not great, but still remain unchanged, particularly when it comes to your ability to advocate for yourself in the workplace. Aniko, any other final thoughts you want to tell everybody?
I think that's it. I think you've
Okay.
covered it all. Thank you
Okay.
so much.
No, thank you, Aniko. Thank you so much for doing this for us. And again, thank you all for viewing our recording. And remember, you can go to the Workplace Fairness website for more information about how to enforce your rights and be educated, and other resources we have on the website. Thank you all.